What?
Good afternoon.
Good afternoon.
Mr. Kolker, will your client be joining us?
He is here. Yes, he's with me
Oh, okay. Oh, in the room with you?
right now.
He's not popping up in a separate Zoom window.
That's right. He's here physically, and my colleague Casey Trombley Shapiro Jonas is also here, but they're not on the camera.
Sure, of course, of course. Okay, great. So as everybody knows, today is May 19th. We're the Board on Professional Responsibility, and we're here in the matter of Inri Benjamin Soto. This is board docket number 20-BD-57, disciplinary docket number 215-D87. So starting with disciplinary counsel, can the parties identify themselves for the record?
Yes, Mr. Chair. My name is Miles Link, representing the Office of Disciplinary Counsel.
Excellent. Mr. Kolker?
Yes, Peter Kolker, and I'm joined by Casey Trombley Shapiro Jonas, and Mr. Soto, Benjamin Soto, is here with me. We're all three of us in the same room.
Excellent. Thanks very much. One housekeeping matter. The record should reflect that Ms. Cassidy, who is one of our attorney members, is not here today. Similarly, for certain reasons, I am informed that Ms. Larkin, who is one of our public members, is in a location where it may come to be that she loses the Zoom connection. Our board rules under Rule 13.6 let an absent member participate in the decision of the board by listening to the recording of the oral argument, absent an objection from the respondent. So, Mr. Kolker, do you have an objection to Ms. Cassidy and potentially, although hopefully not, Ms. Larkin participating in the deliberations, even though they're not here now, provided they listen to the oral argument?
No objection.
Excellent. Thanks very much. Have you discussed who's going to go first in the oral argument? I know there are exceptions both sides, both ways.
We have not.
We have not, but because the petitioner has, because the respondent has filed first our brief and filed a reply brief, I assume that we would go first and also have a rebuttal opportunity.
That's kind of what I thought too, Mr. Link. Is that consistent with your understanding?
Yes.
Okay. So one housekeeping matter before we start the argument. Well, I guess first, Mr. Kolker, how much time would you like for rebuttal? You've got 20 minutes. You can have as much as you'd like for rebuttal. Of the 20 minutes.
We'll reserve 5 minutes.
Okay, great. Thanks. So one housekeeping matter before we get going, as everybody knows, we're on Zoom. As I think we've all learned over the last couple of years, Zoom can be tricky with audio. So it can be difficult if a member of the board has a question to break in just because of the way Zoom does sound. We will raise our hands if we'd like to ask a question, if we're unable to break in. So Mr. Kolker, Mr. Link, if you see a board member with a hand raised, please, we would really appreciate it if you'd let us ask a question so that we can hopefully figure out what we need to resolve the case. I will try to play traffic cop if it looks like that's not working out successfully. Okay, with that, Mr. Kolker, whenever you're ready.
Thank you, and may it please the board. I want to say a word about the case itself here, the underlying situation that Mr. Soto faced in 2012 and 2013 that's given rise to this matter. This was an extremely complicated real estate transaction that actually had spanned more than 10 years that Mr. Soto faced as a surprise, so to speak, because when the case came into him, it appeared to be a routine refinancing transaction. It was only when the title examination was performed that it became apparent that there had been many slips in the effort to get the title in the name of the purchasing entity, which was an entity controlled by Bill Duggan, who owns the Madams Organ Bar. And he has a number of different entities that he uses, sometimes a corporation, sometimes an LLC, but as he testified, and it's in the record, it was all in the family, so to speak. And while his wife was the sole member of the LLC that was the ultimate purchaser, it was Mr. Duggan who was calling the shots. So when this case came in and the complexities developed, problems arose that were not anticipated and that required some special examination and some special actions. The case that we're faced with now is principally a sanctions case because the disciplinary council has not objected to or taken exceptions to any of the findings of fact, but only—
Actually, that was a question that I had for you, Mr. Kolker. Does respondent take any issues with any of the other facts other than, basically for the other violations that the hearing committee found were proven that you've not taken exceptions for? Does respondent, basically agree to those facts that support the violations that were proven?
We don't take exception to the facts relating to the two disciplinary violations, that's 4.1C and D. We do take exceptions to 4.1A, and those and I will address in a moment.
Did you mean 8.1A, sir?
Yeah, I'm sorry. Yeah, 8.1. Excuse me. I can't see it. So we are prepared to address those facts that we think where we think an error was made by the hearing committee in its findings. And there are two of them. One is the claim that Mr. Soto made false statements to the disciplinary council in the course of explaining this transaction when he allegedly said that Lengiswell, which was the ultimate purchaser of the property, had foreclosed on the property. And actually, he never said that. If you look at the letter, which is the subject of the disciplinary council's concern, it was a letter in May of 2015 when this case was first getting off the ground, so to speak. And the principal concern of disciplinary council was whether a forgery had been committed. So the response letter explained why that was not the case. And as you know, ultimately, the hearing committee found that there was no forgery involved. But the point is that the response letter never identified Lengiswell by name. The term lender was discussed in that response letter. Lender in that setting is akin to creditor, so to speak. And as has been explained, a creditor or the entity that stands in the shoes of the original lender has the same rights as the original lender has.
Mr. Kolker, can you describe for me, this transaction leading up to the events in which the respondent was hired I think we can all agree are complicated, right? But at base, who is the lender? The lender, agree with me or not, is the original person who loaned the money to Mr. Littlejohn, correct?
Well,
or incorrect?
I would say no. I would say the lender started out as the original entity that made the loan. In this case, it was Perpetual Bank, which was a large bank in DC at that time, which went out of business, and its loan was purchased and then purchased a second and a third time. And ultimately, it was Mr. Duggan's entity that acquired the rights that lender had by reason of the loan to either foreclose or accept a deed in lieu of foreclosure. So while the original lender, that is to say the entity that advanced funds to the Littlejohn family in the 1990s, was no longer the lender holding the promissory notes, that entity had developed into a series of different entities, and it became an entity known as Coles Farm, which was the entity controlled by Daniel Solomon. And he and Mr. Duggan were friends. Mr. Solomon advanced the money through his entity.
No, I understand all that, but the sentence that is at issue is the actual consideration. This is from counsel's letter, right? Which is DCX 163. The actual consideration for the deed was $450,000, and was based on the loan the buyer provided to the decedent, which was never paid back and forgiven by the deed, and all the buyer's costs to upgrade the property and pay property taxes over the years. So focusing on that phrase, based on the loan the buyer provided to the decedent, would you agree with me, sir, that there was never a loan that was made between Len-Just Will, which was an entity that was only created rather recently prior to the deed being even executed, but there was never any loan between Len-Just Will and the decedent, in which case it's the Littlejohn's estate?
Well, as I tried to explain, the Len-Just Will did not advance the funds in 1996. That we all acknowledge. But Len-Just Will became the holder of the rights that the original lender did. So it stood in the same position as the original lender, in much the same way that if you or I were to buy a home and borrow money, and the original loan was financed by, let's say, Citibank, and Citibank sold the loan, as they often do, the next holder of that would have the same rights as lender that Citibank originally had.
So if we go back to the original loan amounts, right, there was for about four amounts: 205,000, 100,000, 50,000, and 25,000, right?
That's
$25,000 was paid off, and then you had the remaining, the 205, 100, and 50, correct?
Yes.
And those are the three loans that were defaulted on, that became what's called the three defaulted notes, or the three notes, correct?
Yes.
And then at some point, and correct me if I'm wrong, one of these defaulted notes, the $205,000, was never transferred to 2461, which was the entity that was owned by Mr. Dugan, correct?
No, that's not correct. What happened was all of those notes, except the $25,000 note, which had been paid off, were acquired by Solomon's entity, Coles Farm. And then Mr. Duggan gave Coles Farm a note for $350,000, which was to purchase those notes that Coles Farm had acquired. So although the assignments of those notes was never actually consummated in the formal way that you would expect if you had commercial lenders, here, because Solomon and Duggan had a friendship and an informal way of dealing with each other, they transferred the notes with understandings. That's why Duggan paid $350,000.
So I'm looking at finding of fact number 18, which again, according to your initial statement, you were not contesting, states it was undisputed that the chain of endorsements for at least one of the three defaulted notes, the $205,000 note, did not include 2461 Corporation, as the endorsements ended with Coles Farm.
Well, that's right. What happened was Coles Farm acquired these notes, and then Mr. Duggan's entity, 2461 Corporation, executed a promissory note to Coles Farm for $350,000, with the understanding and expectation that what he was paying for by giving that $350,000 note was the three notes that Coles Farm held, so that he, Duggan, or his entity, would have the rights of a lender to acquire the property by foreclosure or deed in lieu. But certainly true that the formalities that you would expect did not take place, but that is
But the point of all this is to say, when you said that basically Len-Just Will stood in the shoes of the lender, which really means shoes of 246, who was receiving these or executing these notes with Coles Farm. So Len-Just Will is standing in the shoes of 2461, but 2461 never actually got title to this $205,000 note, which is part of the three notes that were secured by the property.
Well, when you say it never actually got title to the notes, I don't think that's correct, because in the final analysis, when the the financing transaction was consummated in 2013, Coles Farm was paid for those three notes. The formalities of transferring title in the way that you would expect if you were dealing with commercial lenders and commercial borrowers was not followed. That's true. But functionally and conceptually, the understanding was that those notes were going to 2461 Corporation or its designee, which turned out to be Lengiswell. And that's why 350, or really more than 350,000, was paid at the end of the day to Coles Farm. It was more because there was accumulated accrued interest.
Mr. Colker, can I just ask, maybe this is where Mr. Hora was going, but in that statement Mr. Hora read a minute ago from DCX 163, so I guess what prior counsel in the statement signed by Mr. Soto said that the loans totaled $450,000. I guess perhaps I'm getting lost in the various loans, but how do you get to the 450? Like, which loans are you counting to get to 450?
No, it wasn't that the loans totaled 450. The total of 450 was a combination of those loans, approximately 350,000.
I see. Okay.
Plus 100,000 that was advanced by Duggan, more or less, because over a 12-year period, the records were non-existent. So this was a best estimate from Duggan, which Mr. Soto had to rely on. That 100,000 was used to pay property taxes and some kind of improvements to the property, which normally would have been an expenditure of the owner. So Duggan conceived himself as the owner. 450 was the combination of the note amounts and the advanced funds.
And so I guess the 100,000 we're sort of putting in the Lynn Jess Will kitty because it's coming from Duggan and it's all in the family.
Yes, I mean what it is when the loan was paid off, that's the total amount that was paid was the 350 plus $100,000 that had been paid in the form of taxes and property improvements over the years.
Yeah, that makes sense. Thanks. No, I appreciate that. I know a bunch of other people have their hands up, but one last question sort of along this line. What do we make for the 8.1A charges that these are letters from counsel that are signed by Mr. Soto?
Well,
it doesn't get a lot of, I don't think, much discussion, right? Obviously, he's responsible for his statements. You're not asserting an advice of counsel defense.
No, but the precision, first of all, I want to go back to what I started with, and with respect to the letter that was sent in May of 2015, the focus was on forgery. The effort was to compress the facts here and so that as to be able to address the forgery issue, which turned out to be a non-issue. So there wasn't the detail and precision that we now have in the benefit of 8 years of processing of this case that went into that letter. There was certainly no effort to mislead, and I would like to point out that the Lengiswell documentation was provided in response to the subpoenas to disciplinary counsel in 2016, long before any charges were initiated. So there was no effort to hide this. It was a way of trying to compress it. Now, I see I'm running very low on time. I hope I'll...
Oh, yeah, no, you're fine. I know Ms. Sargent, Mr. Walker have some questions. I suspect we'll go over time. You'll get a chance at the end to make a few closing remarks, and then you've got rebuttal.
All right. Okay. I know there was a question. Was Ms. Sargent who had a question?
Yes. Yeah, I had a question. I just want to clarify. So you're saying that in the sentence, the use of the sentence at issue for 8.1A violation, the use of the word lender, respondent intended that to refer to Lengiswell, which had standing to call itself a lender through 2461?
That's right.
Okay.
It stood in the original lender was Perpetual. Then it went to an estate which bought the notes, an individual, and then he died and his estate had the notes, and then it went to Coles Farm, and then it ultimately went to Lengiswell. So yes, that's correct.
Okay. And I know all the things that you're referring to are in the record. Is there any place in the record where that you can think of now where respondent queued that up, gave that explanation when asked, or?
Oh, yes. It's in the record in the respondent's explanation, in the explanation of our expert witness, and indeed in the testimony of others, including the petitioner or bar counsel's expert.
Okay, thank you.
They differ about the significance. I grant you that, but there was certainly that all the evidence is there of what I just described. And was there an additional question?
My question was similar, and I think it's been covered by your response to Ms. Sargent.
Okay, I want to take just a minute, if I can, without eating too much into my rebuttal time, to address the other statement that was claimed to have been a false statement, and that concerned Mr. Soto's statement that he had conferred with the office of the Recorder of Deeds, Ida Williams, who's the head of that office, and he explained to her how he had come up with the explanation or the way of calculating consideration to include the $350,000 and $100,000 that I just mentioned before. And as you know, Ms. Williams testified in 2021 and did not have a specific recollection of the conversation, though she said she didn't deny that it happened. And she recognized that conversations like these happen frequently and were compressed conversations aimed at determining whether the methodology or concept that a settlement attorney was using and whether it was correct or not. And that's what Mr. Soto said he was doing when he spoke with her. It was a mistake from a hearing committee to think that Mr. Soto was indicating he had gone through the 16 or 17 paragraphs that comprised a narrative of this very lengthy series of transactions. Instead, what he said he was doing was explaining the outcome of those transactions, which gave rise to a method of calculating taxes that Ms. Williams agreed was right, and she agreed at the hearing, as did Mr. McKeon, who was her supervisor. So that's what he was saying, and it is incorrect to think that there was anything false about that statement. Now, I want to say what this gets us to, because this case is principally about sanctions, and there were 3 charges that were claimed by the hearing committee to have been sustained. And as you see, we've acknowledged that there were 2 that we're not challenging. But this one that we are, if you subtract it, then you can see that the proposed suspension of a 6-month period is excessive. And that is true in relation to other cases that the board.
What do we do about the prior discipline?
Excuse me?
The prior discipline seems to distinguish this case from the cases you cited, and I'm not sure how we handle that or how we account for that.
Well, let me address that if I can. First of all, the prior discipline that you're referring to occurred more than 20 years ago, in 1998, and was the subject of reciprocal discipline by the Court of Appeals, the DC Court of Appeals, in 2004, but the incidents involved occurred in 1998 in Maryland. And there are numerous cases in which there has been prior disciplinary actions taken, where the sanction is not as severe as that has been recommended by the hearing committee.
But in those prior instances of discipline, that involved Mr. Soto executing affirming that he was a Maryland attorney in order to effectuate, I guess, the processing of these titles, et cetera, the work that he did, right? That's what he was charged with, correct? And found.
It is correct that there were, I think, 2 or 3 occasions when, in the course of dealing with a stack of documents in 1998, he mistakenly represented that he was a member of the Maryland Bar when he was not. And
do people typically mistakenly represent that they're a member of a bar when they're not? I mean, I kind of take issue with that statement, sir.
Well,
I mean,
I'm not saying he didn't realize what he was signing, but it was an error that he made at that time in the course of perhaps a rushed transaction. But
that's fine.
The point that is important is that Maryland regarded this as not a significant problem and did not impose anything but a reprimand, and at that, a non-public reprimand. That is to say, while it was public, it was the Maryland court specifically said that it was not to be printed in Maryland Reporter or Atlantic Second. So if they thought it was a more serious violation, they would have regarded it as such.
Can I ask, you've indicated that 6 months is too long of a suspension for the 2 violations that Mr. Soto is not taking exception to. Maybe I missed it in your brief, but what are you saying is a fair sanction here?
Okay, I think the fair sanction is within a range of public censure on one end and 90 days or 3 months on the other end. And that is because there are cases that support that level of sanction. Where, or put it differently, there are also numerous cases where the sanction, even though in cases of people who did not have prior instances of improper conduct, where the sanction was much less than 6 months.
Let me ask you one quick hypothetical. Let's say we agree with the hearing committee, all 3 rules were violated. Would you still take exception to the sanction of 6 months?
Yeah, yes, I would. And I can put to you one case that I think is an excellent example of why this is an overreach. You take the case of In re Austern. This was an attorney, David Austern, who was actually involved in handling disciplinary cases as a practitioner. And this is a reported case, and we've cited it in our brief. And while he was acting as counsel in a real estate transaction, he became aware that his client was perpetrating a fraud by producing a check that the client knew, and then Mr. Austern knew was not a valid check. That is, there were no funds backing it. Nevertheless, Austern proceeded with the transaction, and that was regarded as dishonest conduct by the board and by the Court of Appeals. And the sanction for Mr. Austern was a censure. Now, I recognize that Mr. Austern did not have a prior record, but you could say for somebody who was a specialist in the field of legal ethics to commit something like that would have warranted a more severe sentence. So if it's at the sort of short end of the sanction continuum, we think that that's what's appropriate in this case.
Can that case be distinguished at all on the basis of that in Mr. Austern's case, he is simply passing along a document as part of a transaction where your client admits at this point to attaching a notarized document from one to a document that wasn't actually notarized and then recording that with the recorder of deeds. Is there any distinction there at all where in Mr. Austern's case, he seems to be just passing along a check,
No.
even if he knows it to be fraudulent or not, whereas your client is actually actively involved in committing the fraud?
I don't think you've correctly described what Mr. Austern did. If you look at that case, you'll see that Mr. Austern was an escrow agent holding, he and another person, another attorney at that closing, were holding a $10,000 sum, or at least they thought they were, in order to ensure that certain actions took place. And Austern and his client stepped out in the hall during the closing, and the client told Austern, this check is no good. And Austern said, well, we'll deal with that later, or let's not make waves, or something to that effect. And Austern orchestrated the continuation of that closing. So he was not a passive participant in it. He was an active one, and he concealed it. In contrast, Mr. Soto never concealed anything here. He knew that the deed would ultimately go to Era Washington, the attorney for the estate. It's true that he did not ensure that she learned about this in advance of the recording of that document, but he knew that ultimately she would get it. There was no effort to prevent her from learning about it. And he understood that Mr. Littlejohn, Homer Littlejohn, the son of the deceased original property owner, had authorized or approved a change in the recordation tax number from 0 to 450,000. So it's quite different, but in the other direction from what you have suggested.
Excellent. So, Mr. Kolker, thank you very much for that. We'll come back to you after Mr. Link's argument for rebuttal.
Thank you.
Mr. Link, you have 20 minutes on the clock. Mr. Kolker, if I could ask if you could mute yourself.
Yes, sure.
Yeah, thanks. Just to make sure there's no ambient noise. I should have said at the beginning, if you're not talking, please mute yourself. Mr. Link, whenever you're ready.
Let me unmute myself. Mr. Chair, members of the board, thank you. I want to start by noting my learned colleagues' sort of admission that they are not contesting the violations here of Rule 8.4C and 8.4D. Those are clearly the more serious violations in this case. One involving dishonesty as found by the board, as found by the hearing committee, and the other involving serious interference with the administration of justice, both of which distinguish this from many of the cases that they cite in their brief. I would also note that in the Hearn case that the Ostern case, you've just been discussing, again, there was no prior disciplinary history of that attorney. And I think that's significant because the prior disciplinary history here involved similar misconduct relating to real estate transactions. And I note that my learned colleague said that that mistake that happened may have been because it was done hastily. He hastily said that he was admitted to the bar when he was not. While I would question that that's a hasty decision, I do note that in this case, what happened in February of 2013, when he changed the information on the documents that had previously been signed and notarized, he did that in great haste. As the hearing committee pointed out, he did that over the course really less than a day because Mr. Dugan, whom he was basically treating as if he were his client, told him he wanted to reduce his transfer taxes. And in fact, Mr. Soto told Ms. Washington, the probate attorney, in an email he sent to her, the deed was changed in order to assist the grantee in paying less transfer taxes. So, I mean, this was his admission. This was done hastily. This was not a considered judgment of someone who should have known better, particularly when he had gone through the transaction with the probate attorney and with Mr. Littlejohn prior to this, and they had signed off on a transfer agreement before this document was changed.
Mr. Link, I want to ask you about the 8.1A violation.
Right, I was going to go to that.
If I'm understanding correctly, respondent is characterizing the statement about the lender as a high-level summary, whereas your position, as I understand it, is this was a knowingly false statement. And I really have two questions. One is what is your best record evidence that it was knowingly false? And two, how did the statement essentially prejudice, if it did, disciplinary counsel's investigation?
The statement, there are two parts of this statement in the May 15, 2015 document, which is Exhibit 160, Disciplinary Counsel's Exhibit 163. The first is at the top of page 2, and it's the opening sentence in that paragraph. The decedent, Mr. Littlejohn, once owned the property as fee simple, but was foreclosed on by the lender. Then the last sentence in that paragraph reads, the lender was the grantee under the deed and is also referred to herein as the buyer. The only grantee under the deed was the Lingiswell LLC, which could not have foreclosed on the property and did not foreclose on the property because it didn't exist when the foreclosure took place. The ex post facto explanation that we were doesn't hold water. They could have said that not that the lender was the grantee under the deed, but they could have said the lender was Lingiswell as successor in interest or something. They didn't say that. The document doesn't say that. The purpose, of course, was to obscure all of the transactions that took place. Note the hearing committee's proper finding of fact 120. All of these transactions are taxable events. And one of the problems Mr. Dugan had was that how could he affect a transfer of the property if he was not the owner and he wanted Lingiswell to be the owner? So this paragraph, while they were trying to address that issue, this paragraph is misleading because it doesn't provide accurate information when it says the lender was the grantee under the deed. And if I can, I want to go to the second 8.1A violation because that too.
Before you do, Mr. Link, can you answer my second question is if we agree that this was a false statement or at least inaccurate, how did it prejudice the disciplinary council's investigation?
Well, it required additional work to uncover what was actually going on with these transactions. The whole purpose of that May 15, 2015 letter was to provide disciplinary counsel with an accurate review of what the transaction history was in order to show that respondent had acted properly. That's why this letter was submitted. And this kind of obfuscation made that much more difficult both to see and to understand. And again, I point out, it would have been absolutely easy to put in there the identity of the parties by saying the grantee, the lender was the grantee under the deed. Well, the grantee under the deed was Lingiswell, but Lingiswell could not have been the lender because it couldn't have foreclosed. And there was no further explanation like the kind we're hearing today as to, oh, well, this meant that or that. No, that wasn't in that document. That was misleading and it was intended to mislead.
Well, Mr. Link, I'm just curious if you could respond to, I mean, Mr. Kolker sort of framed the context of that letter going over as what was the issue at that point was forgery. This was kind of giving background. And I think the one thing I would expect everyone can agree on this case is that the transactions are incredibly complicated and hard to understand and require a little bit of work to unpack. You could imagine in responding to a forgery concern, kind of going quickly over the background of the case because you want to get to the meat of the issue, which is the concerns about whether there was a forgery. I take it that was Mr. Kolker's argument and that this wasn't, when you look at whether someone's making an intentionally false statement, are they advantaged by the intentionally false statement? Does the lie help them? So I guess what I'm wondering is why isn't that the sort of context in which this letter was written in 2015? And also, how would this have helped Mr. Soto if that is a false statement? If it wasn't knowingly, does that make sense?
Your question does make sense. And I think there was substantial evidence in the record to support the hearings committee's conclusion that this was a false statement because it benefited respondent because it sort of obfuscated what some of the transaction history was. Remember, while forgery was the issue, the ultimate issue was how do you get to this $450,000 transfer when your original consideration was zero? And so by saying the decedent, Mr. Littlejohn once owned the property as fee simple, but was foreclosed on by the lender. And if the lender was the grantee under the deed, well, we're now jumping from the 90s to 2012, 2013, and that sort of obscures the information that went before. And also that, yes.
Yeah, I was going to ask you if looking at the second deed in question, the ultimate deed that was recorded between the estate of Littlejohn and Lingiswell, if you look at the original deed, which had two grantors, which was Mr. Basil, I'm probably pronouncing it incorrectly, as a substitute trustee for Coles Farm and Homer Littlejohn, does that at all put into context the shortcutting by saying that it was basically now Lingiswell as the lender? I'm not really articulating that well. I guess
I think you've done it very well. Here is our response to that. If all of these suppositions were correct, all they had to do was say it. Why this obfuscation? Why not say? One of the points my learned friend says is they never mentioned Lingiswell in this letter. They never mentioned any other party in this letter. They never mentioned Coles Farm with respect to this foreclosure here. Why not? I mean, they had the facts. They could have done so. To say that the foreclosure was made by the lender and then to say the lender was the grantee under the deed lends itself to the conclusion that Lingiswell foreclosed on the property. Now, if they didn't want that conclusion to be made, they could have been more explicit in the letter.
Mr. Link, so you indicated that the prejudice to the investigation was that it required work to figure out and unpack all of this. At any time did they just like walk me through that process? Was it that Mr. Soto provided all of the documents and that's in looking through them is how you uncovered this? Like what is the actual work that was required to realize that the lender that's referred to here is at a sort of the conclusion, and that you had to unpack and find, 2461, and you had to find Coles Farm, and maybe even in the estate of David Levin. Like what was that work?
Ms. Pittman, that's a fair question, and I regret, though, I'm not sure I can give you a step-by-step, since I was not the assistant who handled that.
Can you give me generically?
Well, for example, yes,
were those records provided?
we had subsequent communications with respondent. And in fact, another one of those subsequent communications in October 2015 is the subject of the other 8.1A violation. We had multiple documents submitted back and forth. In fact, the record in this case is voluminous because of the amount of work it took to unpack, as you say, what were the facts in this case. And in fact, unfortunately, it would have been a lot more straightforward to do so had the respondent been straightforward at the beginning. Respondent did respond, we don't contest that, but unpacking all of that, verifying it, going back with further interrogatories and questions, getting additional responses. One of the challenges or one of the criticisms Respondents Counsel has made is that this took a long time to investigate. Well, yes, it took a long time to investigate because it took a long time to unpack the details of these transactions.
And can I ask, how did unpacking these transactions then help you answer the question as to whether or not there was a forgery?
Well, the question of a forgery is an interesting question because the hearing committee found that there was no forgery, and under the law, under the District of Columbia's definition of forgery, they concluded that a forgery had not been proven by clear and convincing evidence. We've not challenged that determination. What was done here was you had these signatures of Mr. Littlejohn, Mr. Homer Littlejohn, and his counsel as witness, and then you had the notary public's form. Those signature pages and notary form were taken off of the documents that they had signed on to and attached to new documents, new pages, if you will, that had the additional, that had the substituted information that respondent had prepared. That was the sum and substance of the 8.4C violation that was found here by the hearing committee.
I think what I'm trying to get at is, how does the involvement of Coles Farm and 2461 Corporation prior to Len Jesswell answer whether or not there was a forgery?
I'm not sure that it answers whether or not, I'm not sure that it answers that question. What it does is provide a more accurate train, if you will, or if this were possession of documents, if you will, a train of custody, as to who were the entities involved in the ownership of this property, in the lending of funds for the purchase of the property, and ultimately who were the entities in a position to either acquire or transfer the property that was the subject of this transaction.
And do you agree that at the time that they were responding to ODC, at that time, the issue that was on the table was forgery?
I do.
Okay.
So I have a question about this phrase again. I know you wanted to move on to the other issue, which maybe we can after this. If we assume that the statement that counsel made in this May 15, 2015 letter was correct, that the $450,000 was based on the loan the buyer provided to the decedent, which was never paid back and forgiven by the deed, et cetera, then that would have made the actual deed that was recorded between Len Jesswell and the Littlejohn estate, that would have been a valid sort of encapsulation of the transaction then. Is that correct or incorrect?
Well, I think that the key word, Mr. Hora, in your question is if, because
Right.
the respondent admitted in his testimony that $450,000 amount was a guesstimate. And remember, only $300,000 of that amount would have represented the sort of loan amount. Also understand Mr. Dugan had originally suggested to respondent the amount of $205,000 to plug in instead of the zero transaction amount. And Mr. Dugan admits that he told him, no, that's too low. That's too low. That's not going to get us above the threshold where we need to get in order to reduce your transfer taxes. So the $450,000 amount was a guesstimate admitted by respondent. And the reason they wanted an amount of that figure was for reasons unrelated to the accuracy of the amount, reasons related to non-payment or the reduction of payment of the transfer taxes. And that's admitted in the documents in his correspondence with the probate counsel in this matter. And it was so found by the hearing committee. And again, I would refer the board, the hearing committee's report is incredibly well done. I would refer the board to findings of fact 57 to 77 and to findings of fact 97 to 103. They are very clear and they go to what I would respectfully request the board, let's not get caught up in the smokescreen of this was a complex transaction. What was done by respondent was done quickly over a period of days, and it was inappropriate, and it resulted in a false document, a falsified document being filed with a government agency, the recorder of deeds, and it required an investigator of the probate division who looked at this and said, wait a minute.
No, we're not understood, Mr. Link. I just, you have limited time, and I just want to make sure that I ask you this other question, which was, let's say that we were to find that the statement that we've been talking about was misleading and not false. Would there still be an 8.1A violation?
I would think that there would be. A misleading statement is by definition a false statement because it is misleading. It is not.
Doesn't the rule actually use, and I don't have the rule in front of me, but I believe it says knowingly false.
And I would argue, as I thought I did, but I'll repeat it, this was clearly knowingly, to use your term, Mr. Hora, misleading, because they could easily, if the ex post facto explanation is to be believed.
But there's a difference, though, Mr. Link, between knowingly false and being misleading, right?
Between knowingly false and knowingly misleading, I would suggest the difference is a very fine line.
Okay.
And I'd like to also go, there was a second.
Ms. Sargent has been trying to get in for quite some time. I know I interrupted you at least once, which is rude.
I'm sorry, Ms. Sargent.
That's okay. Thanks, Mr. Link. You know, one little bit of discomfort, at least for me, is that this false statement occurred in a letter that was written for respondent by counsel. And, you know, part of the reason you have counsel, and I understand he's certified to the truth of the statements, but there's an art to writing a letter on behalf of a client. You make certain, even factual statements in an argumentative way. And I guess I'm having trouble of conceiving, there's a line between being misleading and fairly characterizing facts in a way that will be advantageous to your client. So if the big issue and the big worry at the time was the forgery allegation, and counsel makes a decision, that's one thing. I don't think it's in the record, but it can't be ignored. This is not an affidavit or a declaration. So I'm just interested in your thought on that.
I think that's a fair question, as I think all of the questions on this point are fair. I think the standard of review is that, was there substantial evidence in the record to support the hearing committee's conclusion, not that you might have made a different conclusion. And I think the evidence clearly is, as I hope I've explained, I think there is substantial evidence in the record to support the conclusion the hearing committee came to, that this was a false statement. Are there other possible interpretations of this? Yes, there are. I do think that the reliance on, well, the letter was intended to address the forgery, so therefore we should ignore or downplay any other misstatement. With respect, I think the suggestion to do that is misplaced, because they understood, and certainly counsel understood, and respondent, who himself is a lawyer, let us not forget, and who signed off on the document, understood everything in the letter was subject to review by disciplinary counsel as we were reviewing the whole transaction and what had occurred when the ultimate deed and tax documents were changed. So and again, given how easy it would have been to have been clear and correct on this point, I think the reasonable conclusion the hearing committee reached was this was a deliberate misrepresentation. I want to go to the second letter, and that was.
Well, go ahead. I've got a question, but I'll ask it after you talk about the second letter. Sorry.
All right, because again, we're focusing on 8.1A, and that was the October 2015 statement. That's disciplinary counsel's exhibit 186, where respondent said, I contacted Ms. Ida Williams, the recorder of deeds, to make sure that the theory behind the calculations of the consideration was sound. And then his next sentence is, Ms. Williams agreed that based on this scenario, the calculation of the consideration was appropriate. This was false because Ms. Williams herself testified that the recorder's office was not aware of the relevant context of how respondent calculated the consideration. Now, that statement was made in order to justify the consideration, but she could not have agreed that the calculation was appropriate, and respondent himself signed off on the previous sentence that he was only contacting her to know that the theory, the methodology behind the calculation was proper, not that the actual numbers he plugged in the actual calculation was correct. As the hearing committee concluded, a roughly 2-minute call would not have adequately described respondent's methodology for calculating the consideration in this matter, and it clearly wouldn't have accurately described what the actual determinations he had made. And again, his multi-paragraph, 17-paragraph document could not have been communicated to someone else in 2 minutes.
Would it have been accurate if that letter had, instead of saying based on this scenario, if it had said instead, based on a summary or a brief summary, that Ms. Williams said that the calculation was okay?
No, because she never said that. She never agreed that the actual calculation was okay. And in fact, she said in her statement, the methodology may have been what they discussed, but not the actual calculation, not his application of the methodology to the facts of this case. That she never, and she agreed the conversation took place. It was a 2-minute conversation, or at most a 2-minute conversation. She could not have agreed. And in fact, with respect, I defy any member of the board to read that memo and those paragraphs in less than 2 minutes and understand it. Yes, she was a recorder of deeds. Yes, she was very knowledgeable in this area. But on the one hand, if I may, respondent tells us this was such a complicated multi-year transaction. Who can understand it? On the other hand, he wants us to believe that he could have a 90-second, if you will, conversation with the recorder of deeds, and she approves the transaction.
I'm looking at the. Oh, sorry. Go ahead.
I was just listening. So if I understand you, you find this statement to be false for 2 reasons. One, because based on this scenario, it couldn't have included all of the complications. And 2, it was at most that she would have okayed sort of the methodology, but not the calculation itself.
Correct.
Okay, just want to make sure I understand that.
I mean, if she approved anything, it would only have been, sure, this is a reasonable methodology. It's interesting though, respondent only, you don't. Her testimony is interesting. She says, I didn't know the context, so I couldn't have approved the actual calculation. Context is critical. A respondent only applied this methodology because Mr. Dugan told them, I don't like the way this is going because I've got to pay all these taxes. And in less than a day, he made a 180-degree turn, threw out the document that had been signed by Mr. Littlejohn, had been witnessed by Mr. Littlejohn's attorney and notarized, and came up with a completely different result. Now,
yeah, Mr. Link, if you asked us or you urged us to read this statement or this affidavit, And it, you know, that the clause or the sentence at issue is in paragraph 18, right? But in
Correct.
paragraph 17, Mr. Soto accounts in great detail about how the 340,000 and then they added the 110,000, basically the calculation that was used in order to come to the $450,000. So he goes through that in great detail. And although Mr. Dugan wanted a much lower amount, he's, you know, he explained to him why it had to be higher than 340, and that was ultimately where they ended up putting 450 in there. So there is some evidence in the record that Mr. Dugan wasn't fully satisfied with Mr. Soto's attempts to lower his tax burden.
But he was more satisfied than he had been originally.
But then, you know, under paragraph 17, there's A, B, and C, where he goes in great detail as to how they, you know, the base amount of 340, the additional consideration, and then the total consideration. And then you get to paragraph 18, where he says, and I think it's important to look at the sentences that precede this clause or phrase based on this scenario. He says, given the unusual circumstances related to determining consideration, I contacted Ms. Ida Williams, Recorder of Deeds, with whom I speak to from time to time, etc., to make sure that the theory behind the calculation of the consideration was sound. Again, why couldn't that refer to paragraph 17, 8 through C, where he's talking about in great detail as to how he came up with the $450,000?
Mr. Hora, I don't disagree with what you said, because I think we're sort of talking across purposes. He may have been saying, in light of the complexity of the transaction as reflected in paragraph 17, I need to talk to Ms. Williams and get her approval. That does not mean when he spoke with her, he gave her all of the complexity that was presented in paragraph 17 in order to get her approval. What he wanted from her was to get to, yes, what you've done is okay. And he was under the gun. He wanted to do this quickly. Mr. Dugan wanted to do this quickly. And all of this material written in this memo was written after his conversations with Mr. Dugan to try to get him to try to change the original zero amount to some other amount. So he then wrote down this description of his methodology. For example, he could have emailed this or faxed this to Ms. Williams and said, why don't you read this and then let us talk then after you've had a chance to read this and review it. He didn't do that. So the
Is there
supposition
anything in the record to say that Ms. Williams would accept anything like that?
Well, an attempt was not made, so we don't know if she would have accepted it. She did accept his phone call, and they had this conversation. But there's no way, and as the hearing committee correctly found, there is no way a less than 2-minute phone call could have, Mr. Hora, reflected the complexity that you've identified.
But that's exactly the point I want to make. It's your contention that based on this scenario referred to the fact that he was basically knowingly misleading or making a knowingly false statement, that he had communicated to her all the complexities of this transaction, starting when Mr. Littlejohn took out the money and then died. I mean, starting from that point forward, that's disciplinary counsel's position, that phrase based on the scenario meant that he had communicated all of that information to the Recorder of Deeds. Is that correct?
Well, the word all gives me pause. He had certainly communicated most of this information, because he says, based on this calculation, based on this scenario, she agreed the calculation of the consideration was appropriate. That was the answer he wanted to get to. But if he had given her all this information, she quite reasonably might have said, you know, I let me get back to you, or I don't know. Or Ms. Pittman, she might have said, I can't really go into this detail. He had a quick conversation with her to try to get her to say yes to something which he could not in that conversation have described in the level of detail you just pointed out was in the document, and which she herself testified, I couldn't have approved the consideration. I didn't know what the context of this was. I didn't have that information.
But generally the Recorder of Deeds, did she not testify that she was okay with the method of calculation? Didn't she testify?
Well, but with respect, the question, the method of calculation and the actual calculation are interesting issues. He speaks about he wants to share with her the theory behind the calculation in order to get from her approval or her agreement that the calculation of the consideration was appropriate. Those are two separate things. And remember, he came up with this calculation of the consideration. His application of the theory, he applied it in less than a day because he was under the gun to change the amount to reduce the transfer taxes due. That was the purpose. Now, theoretically, had this been how the transaction had actually taken place, this would have been in the original document. In the original document that was signed by Mr. Littlejohn and witnessed by his probate attorney and notarized by the notary. It wasn't in that original document. The original document reflected the understanding of the parties to this transaction. This change was done. Now, we can change our methodology, and the new methodology may be correct as a methodology, but it may be incorrect when applied to the facts of this case. The facts of this case suggest that the original proposal was correct. Mr. Chair, I will not have a chance.
You've got just a very brief chance. I know we're keeping you over and we're asking questions. We're responsible for the clock too, but
and I would like to go over
30 to 45 seconds to sort of.
I appreciate it. I just wanted to go over some of the cases which respondent had cited. In the Orstern, Schneider, and Zillow cases where dishonesty resulted in less than 6 months suspension, those respondents had no prior disciplinary history. We have prior disciplinary history here. In the Reebok case, the court said, and it's worth remembering, the false signing, notarization, and filing of a pleading formed a dishonest course of conduct that is plainly intolerable. And that's what we have here. Now, in that case, the en banc majority of the court did impose a 6-month suspension, but it did so because, again, those attorneys had no prior discipline. They had unblemished disciplinary records. Even so, there were 3 dissents from that sanction recommendation, which would have imposed a 12-month suspension. And here we do have prior disciplinary history, and we think a 12-month suspension is appropriate. We agree with respondent that the misconduct in Greenspan was so egregious and serious as to require a fitness requirement in addition to a 6-month suspension. Disciplinary counsel is not seeking a fitness requirement in this case. But given the multiple rules violations, given respondents' disciplinary history, given the fact that not just the courts, but another government agency had to deal with this falsification, and given the fact that Mr. Littlejohn and his counsel had to answer questions put forward by an investigator of the probate court and explain what had happened, which had been done without knowledge or consent, we think the message this board should send is that this is serious misconduct, and a 12-month suspension. In Hallmark, respondent received a 90-day suspension, but there was no 8.4D violation there. And in In Re Spikes, our view is that case is completely irrelevant. That case did involve an 8.4D violation, but there was no 8.1A or 8.4C violation in that case. And instead, the underlying issue was the filing of a false defamation action in violation of 3.1. That's not the issue here.
Thanks very much, Mr. Link. Mr. Kolker, you have 5 minutes, although I feel I'm almost saying that facetiously. Please begin when you're ready. Oh, and Mr. Link, if I could ask you to mute your microphone. Thanks.
Thank you. There are a number of issues that I need to address here, and I'm going to start with the one that was the most recent focus, which was the question of what Mr. Soto discussed with Ms. Williams in 2013. And first, I want to point out something that I think helps explain part of the complexity of this transaction. This was really 2 separate transactions, and they took place at different times, and that contributed to the problems. The front part of the transaction was that the transferring title from the Littlejohn estate to Lengiswell. And that deed was originally executed in December, but the recordation couldn't take place until the financing was in place, which was not until the following February. That disjointing made for some of the problems that we confront here. But I want to deal with the Ida Williams issue first, and the complexity of it and what was necessary to explain. Exhibit 108 in this case is an email exchange between Mr. Soto and Robert McKeon, who is the deputy chief counsel to the DC Office of Tax and Revenue, and he is Miss Williams's boss, so to speak. And Mr. Soto wrote the following: "Hi, Bob, I have a general question. In cases involving a deed in lieu of foreclosure, where the secured lender purchased and was assigned the note, is the consideration the amount the lender paid for the note/debt? Thanks." That was the question. Mr. McKeon, the same day, wrote back, "Ben, generally the consideration for the deed should be the amount the lender is paying for the note, plus any other consideration as to the acquisition of the real estate. Hope this helps." Now, what I just read you, I read you in less than a minute. And that was the essence of the conversation that Mr. Soto had with Miss Williams. Is this a proper way of calculating, a method for calculating the consideration? And remember that in paragraph 18, which Mr. Link referred
Mr. Kolker, may I interrupt there?
Yes, sir.
I take your point on that, but could you address Mr. Link's analysis of this statement based on questioning by Ms. Pittman, that there are really two parts of this second statement that are problematic. One is the based on this scenario segment, and then the statement that based on this scenario, Ms. Williams agreed the calculation of consideration was appropriate. Even what you're saying indicates that at most she would have agreed that the methodology was appropriate, but here this statement indicates that she agreed that the actual calculation was appropriate. Why isn't this last part of the statement a false statement?
Because calculation is a method of arriving at a number. It is not, Mr. Soto did not say that Ms. Williams approved the $450,000 number. What he said was she approved the theory, and I'm quoting from paragraph 18, behind the calculation of the consideration. In other words, how I arrived at the actual number, but not the number itself. And as Ms. Williams testified, she does not get into the nuts and bolts of the actual number, but only the conceptual way of arriving at a number when she's often asked about that. So I think that this statement was correct. Now, I want to refer back to the—
Isn't that a lot to unpack out of that brief statement to get from what you're saying to what you're saying from that brief statement? There's a lot that goes unsaid there, isn't there?
Well, I don't think so, because what I read to you about from Mr. McKeon shows the same thing, that he validated the calculation or methodology that Mr. Soto was asking him about, and which Ms. Williams said was correct. And in her own testimony, she did not disagree with this method of coming up with a calculation. She didn't have the schedule that took the note at $350,000, added $100,000 for taxes. That's true, but she didn't need to have that to approve that methodology. Now, I do want to quickly say something about two things here. One is that with respect to the first statement, that this was written by Mr. Soto's original attorney, who was focusing on the forgery issue we've already discussed. Subsequently, Mr. Soto engaged new counsel who wrote a much more extensive, and this was before we were in the case, a much more extensive exposition in October of 2016 of what had happened here. So he put meat on the bones that had been perhaps not as carefully constructed as one would want. But there was no obfuscation, as Mr. Link likes to say, or any effort to prevent disciplinary counsel from learning about what happened. Mr. Soto had his entire file, 550 pages for this closing, which is probably triple the size of an ordinary closing file, provided to disciplinary counsel in March of 2016. So they had all of the raw material here, but somebody has to explain this, and it's not something that can be done in 15 minutes. So that's why that happened. And finally, I want to say on the sanction issue, I know I'm out of time here. If you look at the Rosen case, that's an example of a case where an individual had prior disciplinary record, and he got a 6-month suspension for what was much more egregious than than what happened here, which, by the way, I want to emphasize was unintentional on Mr. Soto's part. It's not like in Rosen. Rosen made false statements to the court about a motion and so on. What Mr. Soto did was he did not ensure that Arrow Washington was in the loop. That's what happened, not that he was intending to deceive anybody. So that's why a reduced sanction compared to what Rosen got, which was 6 months, is appropriate. And something closer to what Austin got. Austin was an expert in this area. If there's anybody who should have known what was the right way to do something and what was wrong, it should have been him. And yet the court validated a much reduced sentence in his case. And that is the starting point, I think, for which you have to examine what should be the outcome in this case.
Thank you very much, Mr. Kolker. Thank you, Mr. Kolker, Mr. Link. Very engaging argument. The case is submitted. Have a great day.
Thank you.
Thank you, Mr. Chair.